Yeah, there's quite a few things that I think you need to think about when preparing your summary judgment and making your arguments at the hearing. The first step, and probably the most important step, is you need to make sure that every ground that you want to raise for purposes of the summary judgment is in writing and is in the original motion. What I mean by that is, if after you filed your motion you discover another ground or you think of another ground, you have to somehow get that in writing before the trial court. This can be done in a number of ways. The first way is file a supplemental summary judgment motion. Now, what this means probably, though, is you will have to allow an additional 21 days before the hearing after the filing of the supplemental motion, because the rules allow the opposing party 21 days notice. A way of avoiding that is you can ask for leave of court to have a late raised ground, but that's left to the discretion of the court. So the better practice is try to make sure your first motion contains all of the grounds that you intend to rely upon. Also, all evidence that you will rely upon at the summary judgment hearing must be attached to either your motion, if you're raising a traditional motion, or your response, if you're responding to a traditional motion or a no evidence motion. You can't attach additional evidence to a reply, and you can't bring new evidence to the hearing. If it so happens that you have already filed your motion or you have already filed your response and you collect additional evidence, the options are, number one, file an additional motion with the new evidence attached, or two, again, ask for leave of court to have the court consider the late filed evidence. It's up to the discretion of the court, and the court is afforded great discretion in making rulings on such motions. The second thing I really think you need to consider when preparing your summary judgment motion and preparing for the hearing is if you intend to make objections to the summary judgment evidence. If you do make objections, you need to have some way of getting the rulings on the objections into the record. So if you do intend to make objections to summary judgment evidence, you have to find a way to get the ruling by the trial court into the record. Most summary judgment hearings, a reporter's record is not requested. A court reporter isn't present. So you can't rely upon any oral rulings by the trial court unless you have requested the court reporter to take down the record. The best way to ensure that you get a ruling in the record is to take with you a prepared order that lists out your objection and allows the trial court to sign off on the order, making its rulings onto the document, signing the document, and having an order that would be present in the record to show the trial court's rulings on your objections.